Simon has now joined us, so I think we will then move to Simon's discussion about electrification of bills of exchange.
Okay, thank you, Jen. Can you hear me?
Yes, I can hear you.
Yes, I can hear you. Oh, good. Thank you. I'm afraid I've had dreadful IT problems, so I'm joining remotely via my phone. So if this all goes south, that will be why. Yeah, the reason for thinking this is worth drawing to the attention of the wider group is that we've spent quite a lot of time thinking about how bills of exchange work in the crypto world, and I think it throws up some interesting legal quirks which are possibly worth talking about. Now, the key issue here is that we have the Electronic Trade Documentation Act, which of course was designed to do something entirely different, but because bills of exchange are a necessary component of trade documentation, included bills of exchange in its list of documents that, although in electronic form, should have the same effect as they would have if they were in paper form, which sounds relatively uncontroversial. Now, as I think I've pointed out to this group before, most commercial lawyering is really nothing more than glorified conveyancing. By and large, the rule as regards any chosen action, which of course includes right of payment, is that the transfer of that chosen action happens according to the law of assignments. There are various exceptions to that. Bills of exchange are one of them. The Bills of Exchange Act really does very little more than to create an exception to the law of assignment by which particular money claims are capable of being reified into a piece of paper and transferred by the physical relocation of that piece of paper. So the question of how you apply that to something which is no longer reified into any sort of possessory property is actually not, as you can imagine, entirely straightforward. Now, the other thing about bills of exchange, which is kind of important in this context, is that the nice thing about a bill of exchange is it has a situs, and that situs is very clearly demonstrable at any given time. And a surprisingly large amount of stuff relating to bills of exchange actually turns on the question of the situs of the bill. So first question is therefore, well, how do we know what the situs of the bill is? And by the way, situs in a way and the location of the parties is important because bills of exchange actually contains two slightly different sets of regimes according to whether a bill is a foreign bill or an inland bill. And the way you decide which it is by looking at the situs of the bill and the parties. So once we've taken the physical piece of paper away, then the first question we have to answer is, well, how do we determine the situs of the bill and the parties? Now, one of the things that the Electronic Trade Documents Act says is that a bill is only legitimately dematerialized if it is transferred through what is described as a reliable system. There's a certain amount of debate as to what you have to do to be a reliable system. But I suspect that someone at the top of the list is you probably need a rulebook. And one of the things your rulebook is going to do is to some extent, prescribe the situs, at least of the system itself, and arguably of the bills created within that system. So what we've sort of reversed into is our old friend, the question of to what extent is it possible to determine by agreement the situs of a particular instrument. I'm going to come back to that because there's more to be said about conflicts. But you then move on to the next big issue, which is that the way that you trigger an actual payment obligation, an immediate payment obligation under a bill of exchange is by presenting it. Now again, presentation with a physical piece of paper is a relatively easy thing to spot. You know, did you hand the bit of paper over or not? The question of what constitutes presentation within a system is not entirely free from doubt, but it actually triggers in effect the same question as the citor's question, wearing a different hat. The rules of the system will unquestionably provide that a bill is presented where the following things are done in relation to it. And so where does it, so is that going to be sufficient? Can we, and what circumstances do we go behind the rules of the system and say the rules of the system may have said that, but actually if you were dealing with a physical piece of paper, you would have had to have done something different. And we don't know. I mean, the issue of presentation is actually quite interesting in a broader scale. It's surprisingly relevant to things like things like stable coins and anything which is expressed to be exchangeable, because the key question is, at what point has the issuer of the bill defaulted on his obligation to make payment? Because the obligation is kind of a new beast as long as the bill continues to circulate. But when does the music stop exactly is actually quite a hard question to answer. And even if you've got some rules that enable you to identify it, it's actually slightly harder than you'd think. There's the bills of exchange specifically. There's another issue as well, which is that if you're a holder of a bill of exchange and you don't present it reasonably promptly, the obligations under the bill of exchange fall away. Now, that's not, of course, as bad as it sounds, because the fundamental obligation to pay that the bill was given in exchange for probably remains in existence. But the point about bills is that they're actually rather fragile things, because effectively what the law says is if the holder doesn't behave properly or behave with reasonable diligence, then the bill ceases to have effect, and the holder is thrown back on the ordinary rights he would have had anyway. Now, there's an interesting question about whether that has any relevance outside the specific provisions of the Bills of Exchange Act. But the fundamental point that the holder of an instrument might owe duties either to the issuer or to other people, not to sit on his hands indefinitely, is one that is really quite interesting. And by the way, it throws up some other fascinating points about when the limitation period would start to run in questions like that, which are kind of hard. The next point is an interesting point, and it's something that isn't intuitively obvious even to even to some sort of bills practitioners, and it's this. The basis of a bill of exchange, the question of why is somebody liable on a bill of exchange in the first place, is basically to do with contract. Bills of exchange do not create a freestanding right of action that comes out of nowhere. A bill of exchange is born of the fact that there is effectively an agreement between the drawer, the drawee, and the endorsee, if there is one, to make a payment on the bill of exchange. Now, that has one important consequence, which is that you cannot legitimize a gift, if you see what I mean, by embodying the obligation in a bill of exchange. If I want to give you £100, and what I do is to accept as a drawee a bill in your name for £100, that is no more valid as a matter of contract than it would have been if I had just made a bare unsupported promise. Now, the reason that isn't a problem is that there are effectively two sets of laws relating to this situation. As between what are called the immediate parties to the bill, you can't use it as a way to create an exception to the law of contract. You can't make a legally valid pure gift just by creating a bill. However, once the bill is created, as between people other than the immediate parties, the remote parties, the obligation is valid. And that sort of takes you to, I think, what most people would regard as intuitively the obvious situation. If you If I decide I want to give you £100, I do it by accepting as drawing a bill drawn on me, and you give it to me. Of course. And the final point, which it is entirely possible that some of you may not be fully familiar with Section 72 of the Bills of Exchange Act. This is the thing that relates to conflicts of laws. And the key point here is that the way conflict works in the context of bills is that the bill is regarded as a congeries of separate contracts, each of which is regarded according to its own governing law. So in the paper world, if I draw a bill on you in England, the validity of that will be governed by English law, not surprisingly. If I then go to Holland and negotiate the bill to a Dutch merchant, the validity of that negotiation is a matter of Dutch law. And if the Dutch merchant then goes to Frankfurt and has the bill accepted by a German banker, the validity of that acceptance is a matter of German law. Now, that has been the case in the bills world for a very long time. And the reason for flagging it is that there is a tendency with instruments like this to assume that there's a single governing law governing the instrument, and that will be the governing law in respect of any dealing with the instrument. And the point here is just that it's not the way it works in bills of exchange. It's not necessarily, therefore, the way it should work in any other sort of electronic instrument. Now, the key point about this is that none of these at the moment are questions with hard answers. But by trying to take something as physical as the bill of exchange and fitting it into the world of electronic instruments, you do find an awful lot of fascinating little points which are worth exploring. And I'll stop there.
Thank you very much, Simon.